So, Santanu Mukherjee sir, now you are host. Now you can share the screen.
Yes, I can share the screen. You tell me whenever. Okay,
Yeah.
I will wait for your introduction and then we'll move.
So the point is that now you can allow the participants to join. And
No problem. I can.
Yeah, you can allow.
I can wait.
Yeah.
Should I do something? Because
No, so kindly get your screen on full screen mode.
yeah, I have gone into full screen mode.
Yes, it
Can
is
you
now
see?
there. Yeah, it is there, sir.
Yeah.
So if you can kindly allow the participants to join.
Okay, then I have to go back.
No, not to go back, sir.
Okay. You mean to say?
Kindly make it on full
Okay,
screen
so,
and screen के नीचे ही options हैं. There are options.
Yeah. The point is that if I am on full screen, my screen also shows the same thing. You understand? So if I have to do anything, I have to go back. I have to stop sharing the screen.
So what you can do is that you can press escape key. Escape key. So it will be means come out from the.
Yeah, that's what I'm doing. See, stop broadcast. So now I have escaped. So it is fine. What I do is, see, since I am taking it from the iPad, that is why I'm taking it from the iPad. So if I take it from the iPad, I cannot do both the things together. I don't know in laptop what can be done. So now participants share content, participants admit all. I'm admitting all.
Yeah, admit all. You have to admit all.
Yeah, admit all. Waiting. Okay, they're joining. People are joining.
So it will take another 1 or 2 minutes.
Yeah, that's right. And then
join them.
So this is fine. I will go into screen mode. So in sharing the screen, start broadcast. Yeah. So now they will see the screen. Are you seeing the screen?
It is there, sir.
Yeah, and you cannot see me. You can see the screen. That is it.
Since your photo is there now at Santanu Mukherjee, so it's fine.
So this is fine. Yeah.
So welcome to all participants, and of course, I would like to welcome our very experienced and learned speaker for today's session, and Mr. Santanu Mukherjee. I welcome you on behalf of Department of Science and Technology, Government of Rajasthan. So our learned speaker will be discussing about grants of patents and rights conferred thereby as part of Indian Patent Acts. So let me introduce formally Santanu Mukherjee sir. He is a very experienced person, and we are very happy to have with us. Santanu sir is a PhD in law from World Trade Institute, Bern University, Switzerland, and also holds a master's in international law and economics from WTI. He is a law graduate from Calcutta University. He had been British Chevening Scholar, Fellow at Max Planck Institute for IP and Competition Law, Munich, Germany, and also Fellow of Global Salzburg Seminar. So, and other than that, he also practices at Supreme Court. He's founder of X-League Chambers, advocate, mediates, and policy advisors with office in New Delhi and Calcutta. He specializes in IPR, international trade, and technology laws. He's engaged in dispute resolution practice, including at Supreme Court of India. He also practices mediation extensively, as well as regularly advises institutional and private clients on legal policy matters. So, in fact, so means last year itself, Dr. Santanu Mukherjee was part of our conference at IIT Jodhpur on AI and IP. So, and all those means participants at IIT Jodhpur, they liked him a lot. His talk was really nice. So, and we are privileged to have with him. So, I will request Santanu Mukherjee sir for his talk. And meanwhile, I will also request our participants to kindly raise their queries through chat box. So more or less means today's session will be a different one. So basically, Santanu Mukherjee sir has requested that he will be happy to answer queries as many as means raised by the participants itself. So I request Santanu Mukherjee sir for his talk.
Thank you. Thank you. Thank you. Thank you very much. I have to say, first of all, may I request participants to kindly mute the
I request all
microphones.
participants to kindly mute.
Okay, so let me start. First of all, thank you very much, Dr. Sikarwat, DST Rajasthan, for bringing me in and allowing me to talk to the participants over the air. Interestingly, the topic which has been given to me is very, very relevant, and it's the crux of any patent or in any patent enforcement of patent, prosecution patent, whatever you call it. But it is extensive. It is quite extensive, and I don't think that the short time I have, 10:30 to 12 o'clock, in this short time, I can do justice to the topic, because this topic itself, this very topic, one would need 2 days to go in details, because there are case laws that needs to be discussed, etc. But what I will do today is I will try. Okay, so please mute. What I will do today is talk you through the sections and take more time in certain sections, certain areas where I think it is very, very important. The entire thing is important. Out of that, I will pick and choose and then let you ask questions, interact, because for those who were there in my earlier presentation, face-to-face presentation at Jodhpur, will know that I love interactions, and it should not be one way. With that, I think I will start now. And the topic, the captions on the topic, or what the section actually says, I have changed a bit, because that, just to make you understand my point, the point that I'm trying to emphasize. Any rights, any legal right, if someone gives you a legal right, it is the right that is given by the government, the sovereign government, through an enactment of law. Common law in common law countries, the law of the land, which is through practice, which has been established. In this particular case, when we talk of patents, quite often people think that patent right is a monopoly right. Very often people say, oh, patent right is a monopoly right, which actually technically is not necessarily only a monopoly right or an unfettered monopoly right. What happens is the patent right needs, the government gives you patent, government gives you a lead time to the inventors, subject to certain conditions. If certain conditions are fulfilled, only then an exclusivity from the competitor is given, and that the tenure is 20 years. We can, as we talk through the sections, we will see how the tenure comes in. Now, this section, this right would have quite a number of exceptions. So there would be exceptions there would be conditions. Considering all of this, no one can actually say patent right per se or the patent rights as such are monopoly rights. Now, because of the exclusivity that is being given through the patent, an exclusivity for 20 years, it is quite possible that there would not be any other alternative in the market, and the patent would encourage a monopoly situation, an economic monopoly situation. That is possible, but that is not per se. That is not going to happen immediately if you get a patent. That is not going to happen. So patents per se would not be a monopoly right. Now that is extremely important to keep it in mind as we move. And as we talk about the rights conferred, means what are the rights? If I go and apply for a patent, it is examined, and then I get a right. What exactly I am getting? Because patent is intellectual property. It is nothing that you can hold, that nothing can you enjoy physically. So what are the rights that you are getting? What are the rights that are conferred? And then we come into section 43. And in section 43, we start with section 43. And you see on the title of the slide, I have said patentability test. But section 43 does not talk about patentability test. Then why am I talking about patentability test? On the left side of your screen, if you see, you will see it is, you can actually see it is what exactly the grant of patents, the patent rights conferred, what exactly it is being talked about. And if I talk you through the section, you will see it says where an application for a patent has been found to be in order for grant of a patent. Has been found, may I repeat, has been found to be in order for grant of a patent. And then there are sub-clauses down. Section 43(1)(a) says the application has not been refused by the controller. The B says the application has not been found to be in contravention of any of the provision of this act. And it goes on to details of there. I'm not going to the details of it. Now, the point is that when will the application for the patent be found in order for the grant? It will be in order of the grant and not in contravention of any provision of this section when at the first and foremost, it meets the criteria of patentability. The moment an application is filed and it goes in for through due process, when it goes in for examination, the first thing which is checked is whether it is new. And when we are talking about novelty, newness of that, because if it is not new, it is not an invention, it is a mere discovery, or not even a discovery perhaps. Now the point is, when we are talking about something new, we are talking about absolute novelty and not relative novelty. What do we understand between the two terms, absolute novelty and relative novelty? Absolute novelty is something which is new in the universe, new anywhere, whether it is in the jurisdiction of United States Patent Office or in the jurisdiction of European Patent Office or independent members of the European Union, anywhere in the world. If it is new, it is absolute novelty. Now, I mean, one might say that, well, it is new in India because no one knows about it in India, and it might be known somewhere else. And that is what we would typically call about, refer to as relative novelty. So first of all, then I come back to the left side of the screen, has been found to be in order of grant. There should be absolute novelty. It should be new at the time of filing the patent, significantly different from whatever is known in public knowledge. That is what I'm talking about. Talking about public, what you call new or novel invention. And when I'm talking of that, we're talking about very, very specifically in terms of the application of the patent And there we are talking about what is beyond beyond prior art. And when you talk about prior art, at the time of priority, whether it is at the time of priority date, at the time of filing, whether it was already known or not, in terms of known as through publication, whatever way, known or not. And then I also mentioned about the grace period, because what happens for the scientists quite often, I don't know how many technologists and scientists are there in the participating today, but you will see that quite often, if at the end of the day, when we are going into of an invention, it is not for vanity purpose to go and say I have 20 patents or 200 patents or 2,000 patents. But the point is making sure that the patented technology actually comes to the market. The patented product comes in for the benefit of the society. That is why the exclusivity is given. And for that, what happens quite often, the scientists, technologists need to come out and give a demonstration, perhaps to possible investment financiers or someone else, that this is how my invention is going to work, and this is how it can be put in the market, and you can make money out of it. You please put money, your money, you will get back returns from your money. My invention will bring you that. When you do that, what happens is you are already going out and you're publishing it. If you publish it in an exhibition or in that sort of manner, you actually lose out the patent. So that is why there are options of certain exemption from losing out patentability, losing out novelty through what we call grace period. And in different countries, it will, some country might not even give. The grace period typically would be around 12. It's in India, it would be 12 months. It can move. Now, once the first test of novelty is done, again, I go back on the left side, has been found in order, and the application has not been refused. So if there is no novelty, the patent office, the controller's office would jolly well refuse the patent, would not allow the application. But that is number one. Now, the point is, the inventor is going to get a market exclusivity for 20 years. And in 20 years, when someone is getting the market exclusivity, there is some give back to the society. And first of all, that the entire thing, market exclusivity, will restrain competition, because that is truth. That is the intention, that you restrain competition because you have invented and contributed to the society. Now, to do that, just new would not work, because if it is new and if it is like, okay, which time this would have come out, in any case, that will not work. So the next requirement is inventive step. And in certain jurisdictions, like in US, they call it non-obviousness. It is the same thing.
Santanu sir, sorry to interrupt you. Santanu sir, sorry to interrupt you, sir. If it is possible for you, if he means due to some connectivity issue, some participants are not able to join. So if you can kindly allow this moment, so it will be the last moment that.
Okay. Give me a second.
So my kind request to participants is that you kindly remain there in the
room
itself.
Just the thing is, I am admitting all who are there, but the only thing which will happen is that I'll have to switch over to admit.
No, sir. It will not means the.
I'm just waiting for a score of. Let me see. There are 91 participants I see now. What will happen is when I take a break and go into another one, I will again get some of them, because we'll have to switch over. Oh,
So we will not. So this is the final thing, sir. So we will not allow from this now. So 91 participants are there. So it will.
so as I said, because I am in the flow of something, if people could not join in time, I have what we can do is we can share because the flow gets disturbed. So
Yeah.
once I finish something and then get to the next, we'll start with the 91. Sorry for those participants who could not join, but the point is this is how it goes in an online platform. Thank you very much. I go back to the presentation again, and I start broadcast from where I had left. So you can see the screen, I hope.
Yes, sir. It is there. It is there, sir. Screen is there.
So as I said, Section 43 talks about grant of patents. When Section 43 talks about grant of patents and 43(1) talks about has been found to be in order of the grant, and then even qualifies more as to the application has not been refused by the controller, and the application has not been found to be in contravention of the provisions of the Act. Earlier, people had talked about it most likely. I come back, this is important, and that is why I say that why will the person, or why will the particular application be found in order for grant? One is it is novel, and the second thing is that just novelty will not work. You will have to have one step above of novelty, main reason being that you are getting an exclusivity. You're getting a market exclusivity for 20 years. And so inventive step is a very critical criteria. And I always say it is a tricky part because it is not something just I say there is an inventive step, not something there is a technical step or non-technical step, but it is absolutely an idea, absolutely a part which is technologically executed, and it is not that anyone would say that just for the sake of saying that yes, this is a step. This is new and this is a step. There are checks. There are qualifications for every technology. Every technology it is that needs to be vetted separately, specifically. There is no point in any manner that it is generic. So the step of inventive step or non-obviousness should be looked at from the patent law perspective. As I said, it is not from the perspective.
Application for the registered construction.
Someone is talking. Can I have the microphones muted, please? Thank you very much. The non-obviousness test is where most of the patent, this is extremely important for the patent examiners, this is most important for patent litigators, this is most important for everyone, because inventive step is one of the crucial areas where the conflicts happen, and this is litigated all through any mature jurisdiction, including India. This is where the disputes happen. So it is extremely important that the inventive step is established. If it is not, the grant of patent will not happen. Novelty, inventive step. And when we talk about inventive step, we talk about who will decide on the inventive step, a person skilled in the art. And so ordinarily, whoever is skilled in the art, if you look into some of the some of the global disputes, quite often you will see there are even disputes as to who is ordinarily skilled in art. There has been dispute also in that whether, in particular, very sophisticated technology, whether a person would need to have a doctorate to be skilled in art in that particular manner. So it is not generic, it is specific. But the general understanding is that an ordinarily skilled in art means a person who would be working in this area. So that's on the inventive step side. And the other is obviously utility. So that's why I have mentioned patentability test. If the patentability test clears, the other issues are more procedural in nature. As it moves through the prosecution, you will see it is more on procedural issues. And as I said, I will talk you through the section, because in each section, certain things are very important for you to look out. And in this short time, I will not be able to go into case laws. I would have loved to go into case laws in details, but unfortunately, I'll not be able to look into. Now, when you're talking about industrial applicability or utility, the invention needs to have a utility, and it should not be just for vanity, as I said. That should not be just for the purpose of vanity. You need to show the utility. And as I said, as you can see on the screen, in Europe and in India, and especially in India, the utility is sometimes very stiff. You need to really establish utility in a specific manner depending on the technology. The other thing which often we forget is enabling disclosure. And here also, quite often you would have conflicts, you would have litigation, you would have challenges, the applications for nullification of patent, because it is not disclosed properly. And properly means the word that we use is enabling disclosure. What exactly we mean enabling disclosure? Enabling means that you need to disclose how you work the patent in a manner, in an enabling manner, or in a manner that enables any one person skilled in the art to perform the patented technology, and further the work of scientific research. That is what is required. Enabling disclosure is the disclosure as to how the person would work the patent. Whenever we talk about rights conferred, we will go later and see what are the rights that are conferred, what can you do with this intellectual property. We'll go, as we talk through the sections, we'll see. But the most important thing is that if these are not in order, then the application for patent will definitely not be granted. This is the very foundation, and I have spent more time in it because this, I think, is extremely important. That's the foundation. Like when you build a house, you really have to focus on the foundation. This is the foundation. Now, I continue. You will see, if you see for section 43(1)(b), it is when everything is in order, where an application for patent has been found absolutely in order, all the tests have been performed, procedural issues have been taken care of, then you get the patent. And when you get the patent, how does it look? I don't know how many of you have looked into this a patent. This is how, in the modern day, this is how it will look. So typically, it would have the date on which the patent is granted. It will be, that is entered in the register. It will have the seal of the patent office, which you can see on the left side. And of course, the authority, the signed signature of the controller of patents, who signs as the authority of the government of India, with whom resides the power to grant. And in the modern day, you will have on the right corner, you will have the scanning code from where you can access. So this is how the patent grant looks like. And now going into the publication of the patents, the patents, if you go back, sorry, sorry. If you go back, you will see that then the patent which is granted needs to be published. It needs to be published from time memorial, from the time that the patent office have been working. We have the patent earlier, we had the patent gazette. Now we have the office journal, the patent office journal, which publishes all the patents. How does it look on the screen on the left hand side? You can see how it looks. And then if you see, go into the page, I am unable to expand it further. You will see that it gives early publications, detailed publications, and everything. Physically, you can hold the book and you can flip through the pages and see. But in modern day, you can also access it online. And on the right side is the photo of the page, how it looks like. I would encourage you that you go on. It's for those who have already not gone to the web page, patent office web page, and looked into the patent, any of the patent website links, sublinks. You will look into applications. You can see applications. You can see published patents. You can see how it is drafted. You can see what it talks about. Everything you can look at. So if you look into section 43.2, it talks about the grant of patent, and it says it should be published and it should be open for public inspection. So this is how it looks. Section 43, I do not want to go in very detail. Section 44, 45, 46, and it talks about the section 44 talks about if where the section 44 talks about the cases where the deceased applicant, the person has died, and what the controller can do, how the controller can grant it, whether it can be granted. Mind you, here it needs to be remembered. One needs to remember that patent is a legal right and a property right. So as a property right, it has all the characteristics of a legal property right. It can be transferred, it can be inherited, it can be passed on, so it can be assigned, it can be licensed. So section 44 talks about in cases where the applicant has died, and of course there are the 45 patent section talks about the date on the application. We always call the priority date. We talk in technical terms priority date. The priority date is the date of filing of the patent. It is the effective date when the consideration, whether it is novelty consideration, inventive step consideration, all looks into, and when it is recorded in the register. And then if you to look into 46, it is the more of the structure, and its ambit, and how it will be. So it will not be in multiplicity, it will not be a bundle. So here one thing I have to say on the practical side of it. So if you look into, there are certain technologies where patents, although as the law is that every patent shall be granted for one invention, but the technology quite often does not work in one invention, like the smartphones or the home handheld devices. there are bundle of patents in that. But there are bundle of patent, each one is applied separately because that is how it is structured. And so Section 46 very clearly says, gives the ambit, it will be throughout India. And so there is nothing called global patents. You might have, sometimes you call world patent, global patent, it is not. People mistake the PCT, Patent Convention treaty applications as global patent. So it is throughout the country. Of course, if there is a customs union, as we say in trade language, like the European Union, the European Patent Office would allow a broader jurisdiction. But as we are talking of, I'm talking in relative terms, but we talk of any sovereign country, it is within that sovereign country. And so 46.1 talks about the ambit that is throughout India, and 46.2 talks about that one single invention and goes into the elaboration of that. I am not going into the details any further. I will stop at this moment and take some questions because we will go into something else next. Can you hear me? I cannot. Hello.
Hello.
Dr. Sikarwar.
Yes, sir.
Can you hear me, Dr. Sikarwar?
Yes, yes, please.
Yeah. So at this moment, I stop to take questions because otherwise we are moving to something else. So that's why I stop to take questions if there are questions. Otherwise, I'll go back.
So I request. So definitely we will take questions. So Rachna Gupta, you have one question. You can kindly ask, sir, your question. Please. Rachna Gupta.
Fine, sir. Thank you, sir. Sir, I just wanted to know because product patent and the process.
Ms. Gupta, can you be a little more loud, please?
Yeah, sure.
Okay, I got it. I've done it. Yeah, thank you very much.
Are you able to get my question or should I repeat it?
Please repeat the question kindly.
Okay, so because product patent and the process patent, these are two different inventions, although for a same product. But sometimes we find patents which are having product as well as process. We call it as a product by process patents. So how can it be possible? Like it is two different inventions. One is a product invention and other is a process invention.
First of all, we are not looking at necessarily two separate things. There can be a patent over the product as well as the process is also patented for that product. That is very much possible. Now the point is, if it is a product patent, it is new. It passes all the tests of product, passes all the tests of patentability, and you get a product patent for that. Now, the point is, naturally, obviously, for every practical reason, since you're coming into a new product, you cannot have an old process to come to a new product. So the process is also patented in this particular case, in most of the cases. What happens is, but there can be already a product which is there, and the process can be new to get to that product. In that particular, if it is already a known product where it is not patented, but suppose you come in with a new process, absolutely you pass the criteria of all the processes, it is possible to patent the process. You will see in certain jurisdictions like United States of America, there are patents over making food products like even idli. And there, what they do is they say that we are only going for the process patent, and we have come across a new process, novel process, meeting the requirements of all other patentability to have a patent, have a process patent. So the two could be separate. The two could be in one single mode. That is quite possible.
But does it not come under two inventions? One is product and other is process.
The point is, if the invention is for, see, as I said, the invention is for the process. In case of process, the invention is for the process, that you have invented a particular process, how it should be done. So the invention is looking into exclusively on the process part of it and not on the product part of it. But if a patent being given on a product itself, and if then where do you have the patent also already exists? If there's no question of having a process, a new patent over a process where the product itself is patented. You got my point?
Yes, yes, that is clear.
If a new product has come and the new product has been already patented, so automatically the point of question of coming a new process to that product does not exist. So both are separate. Now the point is, what I'm trying to say, that product patent, process patent, not necessarily it will be for two. It will not necessarily for the two separate entities. It may be for the same entity. You got my point?
Yes, sir. Yes, sir. Thank you.
Next question, welcome.
Rashmi Singh, your question.
Hello, yes, sir. I wanted to ask if an application is filed and taken priority from a US application, and then I filed in India. Now, my question is, what will be the date of patent of my application in India? Will it be calculated from the date on which it is filed in India, or it has taken the priority from US? What will be the date of patent? In context of
you're talking of the are you talking of a convention patent which has been filed in the US, no. Then you are going for a convention patent here? Or you're talking of your filing in India, and you have considered a priority, a prior art of existing patent somewhere. The priority date.
No, I haven't gone.
Sorry.
Yes, sir. I haven't gone for convention application. I have first filed in US, then I have filed in India, taking priority from US application. Now, what will be the date of my patent in India? Will it be calculated the date on which I have filed in India, or it will take the date as a priority of US application?
If it is not a convention, patent, it will be India.
Yeah, that's what I was asking. It's not a convention. I have first filed in US and then I filed in US only, not through any convention route or PCT. Then it will be calculated from the date on which I have filed in India.
Okay. Yeah.
Okay. Thank you.
Good.
Hello.
Yeah.
Sir, I am Amita. Sir, my question is there any limit to have the number of priority, how much priority we can take from Indian Patent Office for any patent filing? Is there any limit?
I didn't get the question quite right.
Sir,
your voice is cracking.
Just want to know how many priority we can have from the patent office for filing a patent?
How many, what? How many, sorry, your
Priority
voice is cut.
dates. Sir, priority dates, number of priority dates. Hello?
Doctor.
Sir, I'm writing my question.
Ha.
So in the meantime, sir, if you can kindly explain section 45.3. Anshu Nyayapati has raised this query. If you can kindly explain section 45.3.
I will go back to 45.3. Okay. I will go back. Okay. Any other question while he goes? Any other question?
Question from Dr. Madhulika Bangre.
Again, it is cracking.
Hello.
I'm sorry, it is cracking. Yeah.
So,
Sir, I have dropped down my question in the chat box.
Let me look into the chat box. Yeah. Oh my God, that's 67. 46.2. Okay, I am taking the questions from here and then we'll go into it one by one. There are a lot of questions here. I will take the questions one by one. Okay, give me a minute. I am trying to find out where is your question. (45.3). Yeah, so I see 46.2 also. Where is your question? It means infringement is valid after publication only. Yeah, so okay, so I don't know which one is your question. I can see a few questions. Let me take these questions as they are in order here. Okay, so I think I will go back to the screen so that it is easier for you to understand. So a patent shall be granted for one invention only, provided that it shall not be competent for any person in a suit or other proceedings to take any objection to a patent on the ground that it has been granted for more than one invention. Yeah. So let me. Yeah. So the 45.3, I will go with the 45.3 first, and then I will talk about I will go with the 46.2. If you look into 45.3, I will read the entire thing and I'll emphasize. Now, can you see certain highlighted sections? The highlighted sections will address the query that you have raised. Typically, if you see, look into the date of the patent, subject to other provisions contained in the Act, every patent shall have the date. Now the question as to 3 is, notwithstanding anything contained in the section, no suit or other proceedings shall be commenced or prosecuted in respect of any infringement committed before the date of publication or the application. I will give you a live example of it. You will understand. Suppose you have filed the patent and the patent, the date of the filing date is considered as the priority date. And but what happens is, for some reason or the other in the patent, the proceeding, in the proceeding, infringement proceeding, the complainant has gone into the date as by mistake or because of any other reason. The date might have gone before the patent grant date. Now, in that case, it will be nullified. It will not work, because any date, if anyone wants to file an infringement suit, anyone wants to take any legal action, that needs to be from the date of the patent grant of patent. That is the date, or that is the date which is specified in 45.1, and which is supported by 45.2, which is where the same when it is entered. So as I said, the first one is the date, the priority date, that is the date of filing, and that is established in 45.1. And then the same is when it is recorded in the register, that is in 45.2. And then you come into your question as to what is the meaning of notwithstanding anything contained in this section, no suit will be proceedings, or anything in respect of infringement before the date of the publication of the application. So even if it is for some reasons you were aware, you will not take any enforcement action, civil enforcement action, through before the commencement of this date. This is what is understood by this particular subsection of section 45. Next is going into your question as to one invention only. I come back to what I have said earlier, that you may need to protect a new invention, and to do that, there may be related patents, there may be a number of patents. The technology itself may not work in unison with one particular patent. In many cases in pharmaceuticals, there can be one new chemical entity, and there can be one patent over the new chemical entity. The entire thing can be, and the entire technology can be protected through the one single patent. But at the same time, there can be technologies where there may not be only one. You may need a number of patents, and each of them need to be applied for, need to be granted separately. And in any of those cases, the patent shall be granted for one invention, and each of them moving through might be working in unison in a cluster for the particular technology, but each one will be separate. And there is a proviso to it. The proviso says that proviso means there's a condition. The condition is provided that it shall not be competent for any person in a suit or other proceeding to take any objection to a patent on the ground that it has been granted for more than one invention. Like, the point is, when you move into a suit, it can be for many reasons. It can be for nullification of the patent, invalidation of the patent. It can be for infringement proceeding. It can be many other proceedings. The point is, it can move from the IPAB to the High Court. There can be a constitutionality on it, whatever it is. Because you have a technology, as I gave the example of a smartphone, that there each performance might have a patent. For example, for those who are using the smartphone and are familiar with the airplane mode. So the airplane mode helps you to cut off the connectivity and use the phone offline. That is an invention itself, and that invention has a patent. Like that, there are many patents together, and in one single action, also single performance of the technology, also there may be more than one invention. Now in a suit, because there are more than one invention, there will be no reason that there may be an objection to the proceeding. So that is the proviso which is given. And I will now proceed. Otherwise, we'll never be able to finish. I will proceed and then come back to, again, a few questions and see what can be done. Now, typically, Section 47 says, or the wording is, as I told before, when I started, I told that the patent right is not a monopoly per se. Patent right has quite a number of conditions, and also exceptions, exemptions, whatever you may say. Now, I would call this fair use exemptions. It may not necessarily be a absolutely tight box case of fair use exemption, but it can be a stretched fair use exemption. How? Why? I'm getting into it. Section 47 says, grant of patents to be subject to certain conditions. The grant of a patent under this act shall be subject to the condition that machine apparatus or any article made by using a process in respect of which the patent is granted may be imported or may be or made by or on behalf of government, used for its own. It may be purposely for its own use. That is exempted. That qualifies for an exemption from, and then it also includes any process in respect of which. So it is not just the product, not just the machine as a product which may be imported, patented product machine which is imported, but also the process. It also includes the process. In 2, it says the process in respect of the patent is granted may be used by the government or its own purpose. Or so it is, in other words, it is a non-commercial use exemption to the government. Non-commercial use exemption to the government. That is one. The other is, again, given to the purpose of academic purpose. So there again, we broadly call it fair use exemption. Any patented machine, apparatus, or other article in respect of the patent, blah, 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 and or the process in this, they include together, and all process in respect of the patent may be used for experimentation, but merely for the purpose of experimentation. Here, one must understand that if the experimentation is for profitable purpose, and it can be established that the experiment was not for research, pure research, it was not for, but for the purely for commercial purpose, then this fair use exemption would not click. It may be challenged. But otherwise, if it is for research and development, and if it is for the academic purposes, that is instructions to pupils, then again the exemption will trigger. Now, again, there is the 47.4. In 47.4, it says that in case of patent respect of medicine or drug, the medicine or drug may be imported by the government for the purpose merely of its own use or the distribution in any dispensary, hospital, or other medical institution maintained by or on behalf of the government, or any of the dispensary, hospital, or any of the medical institutions which the central government may, having regard to public service, that such dispensary, hospital, or medical institution vendors specify in behalf of notification or in the official journal, official gazette, which will be official journal. The point here is that suppose in real-time situation, it's an hypothetical case. There is maybe a pandemic like what we are seeing now, or otherwise a disease which has devastated the country, and the medicine is not available in India, or the medicine is available in another country at a cheaper rate. And the government brings in the medicine and supplies its government bodies, supplies its government hospitals, dispensaries, etc., without that will fall into the exemptions. Now, this will depend on case-by-case basis, whether the purpose has been only to take care of public welfare, as it mentions very specifically, for public purpose, or and also it is checked that it is not rediverted into the market for commercial purposes. So these are some of the exemptions at this stage. These are some of the exemptions which we see. The next section, we go into the main section in the whole chapter, which says that this is what you get. What are the rights which are conferred? And if you see the rights which are conferred, then you will see that subject to the other provisions contained in this act. Again, like as we started, when we started, that also was the subject to the conditions which are already talked about in the previous section. Why they specifically say that subject to the provisions, other provisions contained in this act and the conditions specified in section 47. They say this because 47 is an exemption. Section 47 is an exemption, and that is why they say that, okay, when we take care of the exemption, and then in 48A, it goes into the very focused subject matter of the patent, and this is in absolute in line, while all the others have been procedural in nature, had evolved through time for the Indian jurisdiction. This one specifically caters to the TRIPS agreement and engages the language of the TRIPS agreement to a great extent. And we see in 48A, very specifically it says that the subject matter of the patent, what would be covered by the patent, it is an exclusive right to prevent third parties. Now we know it is a negative right. You do not get anything specifically, but you get the right to stop others from copying or using the technology in any manner without the permission of the patent holder. And here it does for those that in India. So the language is reproduction, to a large extent, reproduction of the TRIPS agreement, section 27. And we go into the second article, 48A, 48B, the second subsection we see, where it says the subject matter of the patent in process, exclusive right to prevent third parties who do not have his consent from the act of using the process and from the act of using, offering for sale, the same thing, offering for sale, importing, etc., etc. So if it is a process patent, if it is a patent which involves a process, either separately or in unison, as we had already discussed about the separation of product patent and the process patent. And here it is talking about the process and covers the same rights so far. Now, before going into the other sections which are more of procedural nature, I want to bring in the flow. We are talking of rights. We are talking of conferring of the rights. We are talking of what goes on in the patenting process. When will we get the right? When will we not get the right? When we will have exceptions, and when we will move. Now, the entire thing goes in a structure. In the patent office, there is a flow, and I thought of structuring the flow and sharing the flow. I hope you can see on your screen the flow. And let me see if I can broaden it a little bit. I will stop a little bit so that you can have a look into the entire thing, and then I will talk you through this a little more. So you see, there are dual channels shown in the flow chart, the filing. So we wanna, as we write any of the Indian languages except Urdu, from left to right. So we flow from left to right. The flow chart is from in this direction, and we see there are dual channels. Filing of the patent application. From there, one channel goes in with the complete specification, and the other channel goes down with the provisional specification. The two channels we see, and there we see from the filing of the patent, we see with the complete specification, we then move into the publication of under section 11A. This has been dealt earlier, I'm sure, and there are provisions of early publication, and then we see how it moves into the pre-grant opposition, which is there in India. We move into that, and going down as we move, coming into the request for examination. And if you see on the other side, you will see on the second channel, you see from the filing of the patent, we look into vertically, we have a provisional specification. From the provisional specification, we go in a parallel channel. We go into a parallel channel, and we see filing of complete specification within 12 months after the provisional is over, and then again goes and meets to the two. And then in India, as I said, there is a possibility of pre-grant opposition. The request for examination is either it is on the expedited or it is the normal manner. It follows, and then there again we have a parallel channel. We have two. The examination for patentability, there is where the rights conferred issue comes in, and what we have discussed so far, this is where it goes through. And once it has gone through that, the examination report is issued. And then if you look into the parallel channel of the expedited examination, you see, which is there for certain cases, there are certain conditions and qualifications for an expedited examination. There we see, and then again we meet in to one point where the examination reports have been issued. And once the examination reports are issued, from there we get into the next level where the application is put in order as it is looked into the process, and whether there is a need of re-examination, whether it is or there are objections. In cases that is not pursued through, then it will be considered as abandoned. And when it is pursued through, and if there are objections raised by the controller's office, or certain amendments proposed, or any other instructions given, that is gradually met, and at the end of the day, it goes into the grant of the patent. And as we have already looked into section 43, this is more like an reverse. I had gone reverse from the grant of patent under section 43. I moved backward. What are the process that is involved? I get into that particular. That is the particular format that I have used. I will move through because there are many other sections that needs to be talked through. Even when I talk through and explain, I am not sure whether I would be able to complete, because there are many. So I might even skip some, just to let you know now, or speed up some of them. So when we talk of section 49, quite often what happens is that you may have patented products in your vessel which is in transit, which is passing through transit, which is not for a particular transit country, but for some other country. And your patent, as patent rights are sovereign rights, so your product, whatever your product you have, that particular product, patented product, might be, it is quite possible that that is in the destination country, that is absolutely valid. That is absolutely, there's no problem with the validity of that. But you have to pass through a transit country, and in that transit country, it is quite possible that the patent rights of the country would not allow your patented product, whatever your patented product is, would not have that protection. So, or would not confer that protection. So, there can be a complexity, because your patented, maybe your patented product, which is supposed to go through a transit country where the patent is not protected. Like under the TRIPS agreement, there are least developed countries where the patent protection is not needed for a certain number of years, and as of date, it is that exemption lies. Now, in that sort of case, if whether there would be possibility of an patent infringement action or any other action, or in that sense, patent rights not infringed when used on foreign vessels temporarily or accidentally in India, where a vessel or aircraft, I'm going to 49(1), where a vessel or aircraft registered in a foreign country or a land vehicle owned by a person ordinarily resident in such country comes into India, including the territorial waters thereof, temporarily or accidentally only, means exclusively temporarily or accidentally, the rights conferred by a patent for the invention shall not be deemed to be infringed by the use of the invention. And then goes into A, goes into B, and then again has another, A, B is only qualifying it more specifically. And in section 2, it says the section shall not extend to vessels, aircraft, land vehicles owned by persons ordinarily resident in the foreign country, the laws of which do not confer corresponding rights with respect to the use of invention in vessels, etc., etc. I'm going into that details later. Now, in India, the patent rights are strict, absolutely in line with the TRIPS agreement. But the patent rights which is conferred in, say, Papua New Guinea is not the same. They may not protect pharmaceutical, they may not protect pharmaceutical patents in the specific way TRIPS requires them, because they have the exemption of LDC or least developed country. So they do not protect. Now, a generic pharmaceutical company uses that benefit, uses that flexibility. I will use the word flexibility, and manufactures a particular pharmaceutical composition, pharmaceutical product in Papua New Guinea. So ideally, if he had done it in India, it would have violated the patent, but it goes there and manufactures it and wants to travel from Papua New Guinea, say to a Gulf country. And while going so, transits through India. So the moment that bulk steps into Indian territory, as they say, Indian territorial waters, immediately, if it is for the Indian market, then the patent owners would be able to restrain it by using moving on border measures, customs measures, and filing infringement suit. But since it is not for Indian land, it is just temporarily passing through the Indian land, then it will get the exemption. There will be no infringement caused, subject to the fact that it is not put into the Indian market, or by chance, if it is accidentally gone into the market, it is immediately withdrawn. This is the meaning, and it will move in from the dock without coming into the market. Straight away, it will go in for the destination country, and in this case, some country in the Middle East. So this is the example. Now, 49.2 goes into clarifying that if the other country does not reciprocate through similar law, it will not be only one-sided. So if you say same provision should be there, same treatment. I'm sorry, not provision, same treatment should be given to the Indian products, also Indian vessels, also flying into or sailing into or moving by land vehicle into the other country. So this particular section exemption is based on reciprocity. 49.1 AB provides the exemption. 49.1 speaks about the exemption. 41.1 AB details the exemption, and 49.2 qualifies the exemption on basis of reciprocity. Now, let me go into a couple of others. I will go very fast to these provisions. Section 50 talks about co-owners. Now you can read section 50, 1, 2, 3, 4, 5. Of course, there are certain areas where emphasizes in this all of these sections. Certain areas are emphasis. Quite often, those who are working in research institutes, quite often those who are working with corporate sector are working in teams, and the inventors are not necessarily a single person. The inventors may be a group of inventors, and the group of inventors, one person may be a lead inventor, the others may be junior inventors, or it is quite possible that the inventors have absolutely equal contribution to that invention. There may be many combinations of that. This particular section addresses these combinations, quite a number of combinations. And section 51 talks about grant of 2 or more persons, and if there is no agreement, like in most of the cases, if it is in corporate research, even in the academic research centers, usually there are contractual bindings as to what would be the role of each of the contributor. Many a times there is a team which is led by a senior researcher, and there are other junior researchers. So if it is contractual, then in the contract it is also explained that how the share of ownership of the patent is to be devolved. Otherwise, it would be considered, if there is no such contractual agreement, then it will be considered under 50 subsection 1, it will be considered that it will be equally, the shares will be equally divided. And this is, mind you, this is very important, because at the time of monetization of a patent through licensing, the dividends and whatever the royalty or the benefit that is coming, that will be divided as per the contractual agreement that is there, and in absence of that, in the share of each participant of that is who is a co-owner. Now, if you go into the section 52, subsection 2, then you see that the entitlement details as to how it will be, and it builds on. It is absolutely building on 50 section 1, section 50 subsection 1. And as I have already discussed this, when you talk of monetization in any manner whatsoever, how you benefit. They talk about benefiting from the patent. And then in 3, again, that also I have already covered. It talks about benefiting through a license. And then in 4, it talks about when you go to the market, when you take the patented product to the market, then how it will be considered. That is also dealt with it. Who would have the power? It says where a patented article is sold by one or two or more persons registered as a grantee of proprietor of a patent, the purchaser, and any person claiming through him shall be entitled to deed. Here the point is that so the rights will be exactly the same as a sole patentee, subject to the conditions of how it is structured. 5 talks about the rules of law applicable for ownership would be the same as devolution of movable property. I have talked about it in the beginning itself. And then in section 51, which is a follow through of section 50, is now the section 50 talks about the patentee, co-owners of the patent. Now in section 51 talks about the rights of the controller, because everything needs to be clearly demarcated. Here it is demarcated as to the right of the controller, what he or she can do, what powers he or she has. And generally, if you go into the details of it, you will see that the rights are the same as in single ownership. If the patent is owned by a single person, it would be the same as in co-owners. I'm not getting into the details of it. I will go into section 52. Section 52 very interestingly talks about if someone manages to obtain a patent by fraud. Now there is significant strictness in handling a patent right, because an exclusivity is being granted. A legal exclusivity is being granted. So if at the very foremost, absolutely at the foremost, if the right itself is not there, if the right is acquired through fraud by illegal means, then definitely that exclusivity cannot be given. And section 52 elaborates that very well. It says that if in section 52, let me not go through piece and let me talk you through. Here very, very clearly it says that if it is obtained by fraud, there in that case in section 52 subsection 1, it is said that if the patent has been already revoked, if it is invalidated, and it has been invalidated when I'm telling fraud, that the fraud, the word fraud is actually defined or qualified as what exactly you mean by fraud. And here in subsection 1 of section 52, it says, if the patent itself has been wrongfully obtained, if the patent has been obtained against or in contravention of the rights of the petitioner, then in that case, this will be considered fraud. And this in that case will not be allowed. And then it goes into qualify more. If there is already a revocation, already a sort of petition for revocation before any competent forum, and here the competent forum is the appellate board or any court of law, higher court of law. If there is any order passed or a proceeding is continuing, then the whole or part of it which is affected will be considered considered that wrongfully obtained. Now goes into section 52 subsection 2, where it goes it's to very controller do in cases a new patent bearing the same date and the number of the patent is invoked, then we will see that the controller, on request of the petitioner, of course, there is a prescribed form. If you look into the rules, these particular sections should be read with the rules for understanding what process, what procedural action is needed. But it is impossible to do it in such a short time. And I'm just talking you through as fast as possible. We see that in cases where an appellate board or court permits the whole of the patent be granted, a new patent bearing the same date, the number as patent revoked. The number is not going to be a new number. The same number is involved. In cases where the appellate board or court permits a part only of the patent to be granted a new patent for such part, only such part bearing the same date as the patent revoked will be qualified. So these are conditional acceptance, where there are whatever is wrongfully done, that is taken out, whatever is possible, that is granted. Provided required, I see that we have very short time, but try to see how much we can do. Provided that the controller may, as a condition of such grant, require petitioner to file a new and complete specification to the section of the controller. This is very procedural. There is nothing apart from the procedural point of it, which is there. And in India, with the TRIPS, with the compliance of TRIPS, we have changed the tenure, and the tenure for product patent, process patent, every other patent is 20 years from the date of filing. And of course, there is an explanation to it, how it is to be considered for PCT filings. For the purpose of the section, the term of the patent in case of internal applications filed under the PCT designated in India shall be 20 years from the international filing date, according to the patent property treaty. So that's why that is how it is. Well, I'm not going into the other details of the procedural addition. I'm looking into the issue of validity of patents. I've skipped a few. When you talk of validity of patents, the rights to file for invalidation of patents under certain circumstances is also a right under the patent law. So when we talk of validity of patents, what do we mean? Section 56 talks that the grant of the patent, when I started, I talked about the patentability requirements. Under that, the grant of the patent, whether it is the pure or in addition, shall not be refused, and a patent granted as for the patent addition shall not be revoked or invalidated, because it is a patent addition patent, following through 55, following through 54, following through section 54, 55. The ground only that the invention claimed in the complete specification does not involve any inventive step, because the inventive step might have already been discussed in the main patent. In the addition patent, it may not be discussed. So for that reason, there may not be a refusal, there may not be a revocation, there may not be any sort of invalidation, and then qualifies in for 56(1)A and 56(1)B. Going into B, we see that any improvement in or modification of the main invention or an application for such a patent and addition, the validity of the patent of addition shall be questioned on the ground that the invention ought to be subject of the independent patent, not just as an add-on. It needs to be taken in the patent itself together. In 56(2), we're talking about determining novelty of the invention claimed in the specific specification, complete specification, pursuance of application of a patent addition regard shall be had also to the complete specification in which the main invention lies. So even if it is an addition, it talks about the entire specification on the whole. I'm looking into any other issue that are there. There are quite a few things, but I don't think I will go into that. I will open the screen once more and see what can be done with a. Okay, so I come back and see what are the, if there are questions, but there are chat 11. Okay, so there are such questions. Many of the, hello, so many of the, I am reading out one question. Many of the Chinese patents on Google patents have similar language, maybe because of translation, so the rule of plagiarism doesn't apply on patents while drafting. That is no question. So I think limits of priority dates, that's the question. Limits on priority dates. Sir, could you please check the slide you showed on grant certificate? Grant certificate, okay. Okay, any other question? Please tell me. What is the difference between the grantee and patent as mentioned forms? So there are some questions which are as I said, that this particular section that we are discussing is very, very broad and refers to quite a number of them, number of previous sections. Like there is a question from Mauri Ghosh regarding the grantee patentee. This I would have loved to take, but it's not possible to take. There are many others. I'm going into the ones which are, because we are going into extra time. I'm going into few which are very quickly can be addressed, and there are foreign vessels. Foreign vessels. Yes, someone has also already responded. It's anything that floats. Anything that floats, and submarine would not necessarily be considered foreign vessels, because submarines are naval vessels, and we are talking of commercial and any other non-military vessels here. So any vessels that floats, ships. And going into slide grant certificate. Let me check what exactly referring to the grant certificate. Maybe let me see whether I understand well the grant certificate. I will go back and use it. Grant certificate. Start the test. Okay, so Dr. Siparkar, can you read the question, or can the person speak up?
Sure.
What is the question? I think this is what she meant. I'm not sure, but I'm trying to pertain the questions to whatever I have discussed so far, because I don't want to open up.
Yes, sir. So if Dr. Ayushi Jha, if you are there, you can recite your question. Dr. Ayushi Jha.
Yes, sir, I'll ask. Thank you, sir. So, sir, my question is, section 47, it talks about use by the government. And I think section 99, it talks about use for the purpose of government. So what is the difference between the two sections?
Section 47 is used by the government, and section 99 is for the use for the purpose of the government. Very clearly, for example, I give you the example of public use. If there is, for example, let's say that there is a very very narrow scale pandemic in certain area of India. I'm not talking of a global pandemic, or I'm not talking of a pandemic to the scale that the WHO comes and says that it is a pandemic covering X area, and so under the pandemic, this XYZ medicines, pharmaceutical drugs are declared essential, or whatever may be the criteria. There can be many criteria under which the WHO considers the essentiality of certain drugs. There were even, I mean, I'm not going to that. It can be malaria, whatever. So, but the government of India realizes that we do not have medicine, or we do not have medicine at reasonable rate in India for that particular medicine, and it is available. Maybe in Bangladesh, it is maybe available. Bangladesh may not be the right example, because Bangladesh being an LDC, it will, I mean, they might, even now, they do not have the same requirement for patent law, same sort of high standard requirement of patent law. But the government brings in patents. Maybe Bangladesh is an example where the government brings in medicines from outside, which, if not under Section 47, could have been a violation of an existing patent in India. So the government brings in those medicines for particular use. Now, this is an example. 99, these language, but in case it is not clear, now I go back that if the government wants to use it exclusively for the purpose of the government or the government undertaking, then in that case, the government will use it not necessarily for public use, but typically for the use under a government body, for selling it to the central or the state, any state government, or it can be even government undertaking. So that is a very specific, where the invention is exclusively for the purpose it is made for government use. The other will not be necessarily made for government use. It can be for any other it can be any other purpose. But so this one is, there is a thin line of differentiation. So here it will not be for public use, like in use for medicinal purposes or medical apparatuses. It can be many things. It can be absolutely many things. The difference, typically, if you see in real terms, difference will be also on practicality. When I say practicality, I mean that the any use of patented product, there will need a certain payment of royalty. You have to pay royalty for that. Now, in this, there can be use what can be paid, whether it could be paid in one go, because the patent royalty may be on volumes, that and it would differ. It would not be necessarily the same for the same volume. Now the government under these sections may access it at a particular royalty rate, and buy it all, and then distribute either free or distribute at a cheaper rate, whatever they want. Typically they will not charge any royalty, because they do not, under this section, they do not have the power to resell it. It is mainly for the redistribution. So the section 47. On the 99 part, as I said, 99 part is solely for the use of the government or the government undertaking. And there is a thin line of difference between the two. And but we will have to see how it goes us through. I don't think it has been disputed in any court of law yet. I don't think so. So, but in both the cases, the patentee needs to be notified, the patentee needs to be informed, and there is very clear provisions there. And I think in for what exactly government, whether the government agencies will fall into that, or what if you look into government undertakings will be responsible for that. There are case laws. I think there is one case law with the Konkan Railways. I cannot remember exactly. There is a case law. Please research, or I can come back to it later on. There is some case law involving Konkan Railway, which I cannot remember, around 2012, 2008 or 2009. I cannot remember. So there it has been defined as to whether it will be, what exactly would mean as government, and what will be looking into, and whether a railway will be considered government, and whether who would be the involved parties in a government matter. So all these things are there. It is stretching, but there is a thin line between the two, and I think it could have been. I mean, this is my personal opinion. I think this could have been better drafted, and distinction made very clear. That much I can say. And with that, I go back. Someone had asked about the certificate. If there is no question, then I will go back to the screen. Or if there is no question pertaining to any particular slide, then go back to the screen. Is there any question pertaining to any particular slide or any particular section? Any particular section, I can go back to the section and you can see and we can discuss. Otherwise, I will close it.
So Jayamati Pandit has raised the question, sir. So she's asking about the difference between section 47 and 99.
I've already said that when set under 99, it is for government use exclusively. When it is said government use exclusively, then that can be possible for government bodies, government undertakings. But if you look into 47, it can be also for public use. If the government is buying from outside, and just now I gave the example of buying medicines from other countries, which is cheaper than in India, and supplying it in government hospitals. But one thing is very, very specific, that it is not for commercial purpose. So the point is, the government might, if you import also from other countries, if there is a patent, there is a royalty factor which comes in, and quite often the royalty is staggered. The royalty paid is differentiated on the volumes. But in this case, all these under section 47, that can be excused, and the certain royalty can be paid, and the products brought in, because the government is not earning any royalty further. Government is distributing it through its own channels. Similarly for apparatus which can be brought in for research purposes, similarly for certain educational purposes, research exemptions are given, where if you are teaching, you can take the help of 47. But as I said, that the drafting could have been very specifically separated. In the case of 99, it is for the government purposes, for its government own use. you can look into the if you look into the news regarding aircraft technology transfer, you will see there are significant intellectual property involved by way of patents, by way of trade secrets also, but mainly there is huge amount of patents. Now, that would qualify under Section 99 typically, and for government purpose. There are a lot of negotiations which goes on between the two countries. It is exclusively for government purpose, and it is the Section 99 would not necessarily allow public benefit. As I gave the example of the medicines, that would not come into. So there is a thin divide between the two. And as I said, personally speaking, I would have drafted that in more clarity and separated a bit of overlap which is there between the two sections. Any other question? Any other section?
Hello.
Yes, please.
Sir, I have a question regarding the sections dealing with co-owners of patents. There is an expression patents or interest therein that is repeated quite a few times. What is interest therein? That is one. And sir, a second question, what is the difference between grantee and patentee as it refers to forms 16, 17, 19, 20, 21. I mean, I'm not talking about just the definition that is provided in the clause P of section 2. Can you please explain with a practical example what is the difference between grantee and patentee, please?
Okay, so first things first. Your first question was regarding the what did you say? The patent and interest therein, or something you said, right? What was the first question? Patents and interest therein, if I'm not wrong. Can you confirm?
Yes, sir. Yes, sir.
Okay.
Yes.
So it is very interesting. The first thing is that, let me give you absolutely a live example to understand. Typically, I apply for a patent, and I have rights as a patent applicant. I have rights, and after all the examination of the patent, I get the rights, but I die. I'm just giving an example of a scenario. If I die, I mean, by the time the grant has come through and everything has happened, I pass away, I die. In such a case, or this is one case scenario, or by the time I have already discussed my invention with a prospective manufacturer, I am not going to manufacture myself. I have discussed it with a prospective manufacturer, and I have taken monetary consideration, and I have already dealt with the deal that the moment the grant works through and the patent will be assigned or whatever. But let's take the first case, I die. If I die, then there will be, like any other legal right, patent right also, inheritors or anyone, those who have interest in the right. So it will not be only me, but also the persons who have right over the patent, legal right over the patent. Now this may be, so I get a grant, and after grant, this is a scenario where I'm dying, Another scenario is where the right, I've got a right, and then I have already discussed, I have negotiated with the party, with a particular party, and I have assigned the right. So the person who is the assignee, typically would also have the right to the patent. It will not be it would not be exclusively the person who is owning the patent, the first owner of the patent. It has been handed over. The rights there will also pass on to that person. So there can be the persons who would have interest in the patent. It can be, in the first case, it can be person who is inheriting the patent. In the second case, it is a person who has the rights over the patent in the new case. So that is where you can look into the difference between the meaning of interested party, or whatever you said. I don't remember. Therein, the parties having rights therein, or parties having interest therein. Okay, so when, yeah, so what was the other question?
Sir, it was about the difference between grantee and patentee. I typed it also, posted it in the chat box.
I cannot see the point. Yeah. The chat box problem is that I have to keep on switching the screens to look into chat box. I'm opening the chat box once and then looking.
So she can ask here only, sir. So you kindly ask the question, please.
Sir, shall I repeat?
Yeah, I got it. I got it. The point is that the patent term which comes in a person when the patent is granted, the person is called can be called a grantee of the patent. The person, if the patent, you can say that the person has filed the patent, it can be also called a patentee. The person is the patentee. And then if the, I mean, there is, that is very much fine. I don't see any differences.
Dr. Mukherjee, your voice is not audible. Dr. Mukherjee? Your voice is not audible. Hello?
Can you? Yeah. Can you? Oh, I'm so sorry.
Your voice is not properly audible.
Oh, I'm sorry. I will just. Hello?
Yeah.
Yeah. Oh, so you could not hear me?
No, sir.
No, it's fine. It's fine
now I can hear you.
I'm sorry. I'm so sorry. I'm sorry. Okay. So a person who is granted the patent can be called a grantee of the patent. And similarly, if the person, he can also be called patentee. Now the point is, if quite often this is when the patent is, when the patent changes hands and it is assigned, and quite often that person also is referred to as patentee, but would not be necessarily referred to as grantee. So the ownership of the patent the grantee of the patent is the person who has filed for the patent and has been given the rights of the patent.
Thank you, sir.
Am I clear?
Yes, sir. Thank you.
You're welcome.
Sir, what about the trustee?
When you bring in a trust, then a question of the entire, it is different because that you're talking of trust, right? Trustee, what do you mean by trustee? Trust, a patent owned by a trustee? What exactly is the question?
There is a section where they have mentioned trustee, grantee, and patentee. So I just want to, as you have already cleared the doubt between the trustee and the patentee, patentee and the grantee. What is referred by the trustee?
Where do you find a trustee? I'm not getting it. Trustee of the patent. Trustee of the patent. Where do you get trustee of the patent?
Section 51, subsection 4 of 51. So no direction shall be given under this section so as to affect the mutual rights or obligations of trustees.
Yeah. So okay. So when you talk about trustees here, you are talking about, you're not talking of trustees as, now I got it. No, you're not talking about trustees as of a trust society. When you are talking about a trustee, that you are saying where there are two, if I'm 51, you're talking of 51, right?
51 subsection 4.
Yeah, where, that's what I'm saying. You are talking of 51. Here,
subsection
so I was
4.
Yes, absolutely. So when you're talking of 51, you're not talking of a trust society trustee. When you're talking of 51(2), you're talking of the typically those who are entrusted. I will read it so that it is very clear, because without reading, just you pick up one word, the meaning will not be clear. If you talk of 51, 51 says that power of the controller to give directions to co-owners. And then it talks about if there are two or more persons registered as grantee or proprietor of a patent, the controller may, on application made to him in prescribed manner, blah, 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 goes into the grant of licenses under the patent or the exercise of any right under the previous section, which gives in the rights. If any person registered as grantee of the patent, who's the person who has applied for, or proprietor of a patent, fails to execute any instrument or to do any other thing required for the carrying out of any direction given under this section within 14 days after being requested in writing so to do by any other person so registered. This means the persons, authorized persons, the controller may, upon application made to him in prescribed manner by any such other person, give directions empowering any person to execute that instrument or to do that thing in the name and on behalf of the person in default. Where do you find the trustee here? I still cannot understand.
Sir, I said section 51, subsection 4.
Okay. No direction shall be given. I heard the subsection 2. That's why no direction shall be given under this section so as to affect mutual rights or obligations of trustees. Here, trustees refer to people benefiting. They are not necessary. They do not mean members of any trust society as such. They hear whoever is benefiting from the patent, who are either just now the question came in, who would be the assigns or who would be the interested parties. No direction shall be given under this section so as to affect the mutual rights or obligations of trustees or the legal representatives. It is made it more clear. It is made clearer to the legal representatives of any deceased person or of the rights or obligations as such, or of which is inconsistent with the terms of the agreement between the persons registered as a grantee or proprietor of the rights. Here, as I gave the example of death, if a person dies and there are interested persons who could be called the trustees of the person, and it is not necessarily a trust society, but there is also possibility, it's a hypothetical case. In a hypothetical case, the benefits might even go to the trust society, particular trust society. In that, the trustees of that society would be included, but it would not necessarily exclusively mean any trust society. Anyone who is legally beneficiary of the patent can be by inheritance, by way of the inheritor's legal representative, or it can be, here in this particular case, it is more specific to the deceased person. Because as I said, it is a property like any other property, like your house or any other property, which can be sold, which can be possessed, which can be rights of legal rights of which can be licensed, can be sold. So typically the rights can also devolve to the inheritors. That is what it is meant here.
Thank you very much.
Was I clear?
Yeah.
Is there any other related question to this?
No, sir. Thank you.
Okay, you're welcome.
Hello, sir.
Any other question?
Yes, sir.
Yeah.
So what does the word instrument here mean?
Instrument is the legal instrument. It can be, we call the instrument. Instrument is not necessarily a technological instrument. It is not an instrument. It is the means through which you do. It is an instrument. Here is the suppose in case of inheritance through a will, then in that case the will needs to be, that is the instrument, and the sanctity of inheritance through the will be when that has gone through the process of law, and in this case the process of law will be when a probate has been taken. So this is an instrument. So if in the will it is written that I have applied for patent, once the patent is granted, the patent and all the returns from the patent or anything, all the rights of the patent will go to XYZ. That is the instrument here is the will. So, and then as per that, the person might, whoever gets the right to the particular patent through this instrument can exercise manufacture using that patent right, the patented technology, or might assign it and sell it off, or might license it to people who may manufacture, might license, even when licensing, might license exclusively to one particular entity or person, might go for non-exclusive license and spread it out in many. So the instrument is the device, the document, or the which gives the person the legal right in this particular case.
Right, sir. So in connection with this, I have simple one question. So if there is no mutual agreement between the two inventors, Like I have giving, like one inventor is not giving the right to the another inventor, and there is some fight between the two inventors.
No,
And
hold on. Okay, let me hear you first. Yeah.
Can I start?
Yes, let me hear you out first, and then I will. Sorry,
Yes.
I will not intervene. You tell. Yeah.
Yeah, sir. There is no mutual agreement in between the two inventors, and first inventor has sold out or given a license to the third party without taking the consent of the second inventor. So what if the
Okay. So or you have more questions? Should I
no,
come in
sir.
now?
In relation to this only, yes.
Okay. So so if there are two people, you are talking of two people. Let's say two people here.
Yes.
Let's say two people here. Two people are working together, and two people are the two inventors. It is not a case where two people are working on the same project and even competing with each other and coming out, and one gets it and goes through. It is not the case. This is a case where two are working together and two have together invented a particular technology, whatever it is. It may evolve into product, it may not be evolved into product. So both of them have come out together with a particular, and both of them jointly owns the patent. Am I right? So far, am I right?
Yes.
This is the situation.
Yes.
Both have jointly owns the right. If that is so, then both would have equal undivided share. That's why I changed the slide. You look into it. Both have equal undivided share in that particular invention, and both of them ideally one would be able to speak for the other if there is a consent between the two. And so, but in this case, the person has gone against, and there has been a conflict between the two, and the in breach of an understanding, or there is no understanding, there is no agreement at all. So one has gone out and gone to some party and tried to assign it or try to license it. Let's say license it, or assign it, whatever. Let's look into section 50, subsection 3, and read out section 50 as section 53, 50 subsection 3. Here there is a proviso. There is a very clear-cut condition as to when a person can go and what can the person do on behalf of the other, and one cannot do. And I read it out. Subject to the provisions contained in the section and in section 51, and to any agreement for the time being in force. And in our case, there is no agreement. Where two or more persons are registered as grantee or proprietor of the patent, then a license under the patent shall not be granted, and share in the patent shall not be assigned by one of such persons except with the consent of the other person. So if the person goes out, then the person will not be other one who is also a co-owner with equal share. So the point is, the license, whenever the license, if someone goes in for such a license, it will be illegal, and the license will not be registered as per requirement. So that would be a void. That would be a situation of void, and this will be, the other party will be entitled to legal action.
Yes, sir. Thank you, sir. Sir, but doesn't the word equal undivided share mean when it is said undivided? Undivided mean ki each one is having the 100% right. So why one cannot go for the whole patent for licensing or some other purpose?
It has the word is it is said the phrase used is be entitled to an equal undivided share in the patent. It never says that in unison, or it never says that exclusively. The undivided share in exclusivity is, it doesn't say this will be, this is this is a matter of interpretation. I am interpreting, I would say that if the wording had been where a patent is granted to two or more persons, each of those persons shall, unless an agreement to the contrary is in force, be entitled to an equal undivided share in jointly or severally. Jointly or severally. If that is meant, that would have been mentioned, then the person would have gone in for a license, gone in for exclusively for the person's share. Now it is in this particular invention, it is quite possible. It is quite possible that the invention is such that you cannot even divide. So all you can do is divide the share. Undivided share of the entire thing is the entire thing in unison, not severally, not exclusively. The share is not exclusive. That is my reading. That is my interpretation. If there is a matter, this is how I will plead, and the matter is to be taken up. So it is not that a person goes and license. Now the person, I can let us for argument's sake, the person goes into a licensing or into an assigning, and then whatever money the person gets from there, shares it with you. Even then it is not, even then it is a violation, because you have not consented for the license. So it is very clearly said that until and unless, and clearly said in 50 section 50 subsection 3, that unless it is the consent is there of the other person or persons. So even if the person sells it off, assigns it, licenses it, gets royalty money or gets an assignment fee, whatever, and gives half because the other person has half share, gives it, even then it is illegal. It is not possible because the other person's consent has not been given. So it is not possible. It is a violation.
Yeah, thank you, sir. So one thing, does the licensing process goes through controller, or it is a legal process that goes through legal persons only?
Oh, well, I don't know what you mean by legal person. You are a legal person. I am a legal person. Everyone is a legal person. So we are legal
person means.
I understood. Okay, let me just like that on that. The point is, what you mean is that let me. I understood what you meant, and let me answer in this manner. The licensing is absolutely a contractual and the license of a patent is between a licensor and a licensee. So typically the licensor and licensee will negotiate on terms, and these terms will be drafted in a contract, in agreement by a lawyer. The lawyer might also practice patent law, or typically would practice patent law. It would be easier, but not necessary. So this is what is required under the law, as you say, legal person. Now the point is that in India, the registration of the patent is also a requirement, in the sense the registration, if you have to file a report of working of the patent, then there will be requirement of registration of patent license also. You have to get, otherwise in India, registration of a patent license is not mandatory. The patent license can be registered, may not be registered. Whether it is required for for getting money is a contract, you have to go through lawyer, everything is under that. But you can register the license under in India. The registration of the license, again, it is not mandatory but possible under section 68. You can register the license of license agreement, and although it is not mandatory, in certain sections, when you are trying to show working of the patent particularly through patent licensing, then you would have to submit the registration certificate. So 68, 69, you can look into that. You will see that there are provisions for registration of a license. So it can be done. I mean, you may go and do it yourself, but it is advisable. And when if you are working to become a patent attorney, then definitely a patent attorney can do that. And a patent attorney with necessary legal background, legal
so Dr.
qualification can
Dr.
also do the draw of the contract, the licensing.
Thank you, sir.
Licensing.
Yeah, thank you, sir.
Hello.
Yes.
Yeah, Dr. Mukherjee. So I am audible to you, I hope. So since it's already 12:50, so we are over by 15 minutes of the session. And in fact, we have answered most of the queries raised by, and in fact, in 1.5 hour session, it's really a challenge to cover all the technicalities of section 43 to 64.
Yeah.
And in fact, tried your best, and I hope all the audience are really satisfied. And so if you are able to share in next so please let us know. 5 to 10 minutes is fine, or what's your opinion?
Can you repeat the last part? It cracked. I could not hear the last part. What did you say? If you what? If I do what?
So we still require some time to complete, or you have.
Oh, it was so large. I have to apologize. I could not complete. You cannot complete. It is impossible to complete in this manner. If you go all the sections, if you go, but and each one are different. Like if you talk of abandonment, I mean, half an hour can be talked on abandonment. So there are so many things which are there. What I would say is that if you next time, perhaps we can separate it out in 3 or 4, and we discuss it along with the rules, because because they are more procedural in nature. The rules what we have are executing the statutory section. Now, and then also it gives me the ability to discuss cases. Now the cases, because in India, like in any other common law country, the higher judiciary, decisions of the higher judiciary becomes law. So the interpretations by the higher courts of law, that is the high courts and the lower court and the Supreme Court, these will also becomes law. So there was a particular question. Now I could not remember the particular case. It was a Konkan Railway case, 2008, 2009, around that time. But the point is, if it is small, if it is short package, what I can do is if the entire thing in 3 or 4, I can do 1 hour, 1 hour, 1 hour. In this manner, I can take you through the statute, read through the rules, and give you the interpretation of the courts. And with live example, I can. In this, unfortunately, all I could do is read through and specify certain sections of each particular section, subsection, and put it forward, because the wordings are also winding sometimes. It is not possible to understand sometimes. And so that is what I could do. I do not have anything else to say, but I go back when if I have to conclude in 2 minutes or 3 minutes, I will crux the foundation of the rights conferred under patent is the first section, where you decide what will be granted, what will not be granted. And with that, that is the last part of the flow chart I had given. And the flow chart, it is the last part where you have the grant. But when you do the flow chart, you go back and you see the entire process comes through. With that, I would say that for anyone who wants to understand the rights conferred, it is extremely important to see the sections, the patentability issues, the inventive step requirements, and look at case laws, how inventive step has been defined in elaboration. And with that, the entire flow, section 43 onwards, will be clear. 4799, the difference between 4799 will be also clear as to who would be considered government bodies, public sector undertakings, what would be their role. Whether I bring it from outside and distribute it to people, medicines, can I, even if I have paid royalty, can I ask for the royalty without any compensation? Just that, whether I can, whether I cannot, everything will be elaborate. I have given certain examples in the short span, but we can go in detail into that. With that, I would end, and I said thank you very much. I had kept I knew that it will expand, so that's why I had kept provision beyond 12 o'clock, I knew. With that, I thank you again, DST, for giving the opportunity to interact, and I'm sure we can interact later on also. Thank you.
Sure. Dr. Mukherjee, thanks a lot for you have given a clear overview of these sections, and of course an idea to our participants to look into the matters. So thanks again for your time, wonderful time, and hopefully in future also we will have you in our, since we have initiated many IP related things, new things in Rajasthan, definitely we will have you an expert. We will take your expertise on those matters also. So thanks, Dr. Mukherjee, and to all our participants for raising right queries, and I hope most of the queries have been answered in a very right way by our learned speaker. So thanks a lot, Mukherjee sir, and thanks to our participants also.
Thank you very much. Thank you.